Afternoon, you may be seated. All right. So we're here on the sentencing of Shelby Neely. This is State of Florida versus Shelby Neely, case number 19-00140. Obviously, under the new statute, the trial judge is mandated to do an opinion, whether it's going to be life in prison or the death penalty. So obviously I have...
Right out of the gate, the judge dropped something crucial. He's already made the sentencing decision. That means everything we hear from this point forward, including emotional testimony, won't legally change the outcome. So why allow it? Because under U.S. law, victim impact statements aren't about influencing the verdict. They're about giving families a voice. But here's the question. Does that make this moment more about justice or closure?
Done that, so anything that I hear at this point will not affect the sentence because the order's already done. But I do think that the victim's family has the right to be heard. They did testify pursuant to Florida law and the law of the United States as far as victim impact is concerned, but they really haven't had a chance to say how they feel about the situation and what sentence they would like. So they may do that at this point. So, State, would anyone like to address the court at this point?
Judge, may we approach briefly?
Yes. All right. State, would anyone like to address the court at this point?
Now we're about to hear from a key figure. Not just a grieving sister, but the person who stepped in to raise the victim's children. This is where courtroom procedure collides with raw human reality. Pay attention here. These statements often carry emotional weight that juries remember forever, even if judges technically don't factor them into sentencing.
Yes, Judge. Ms. Stewart, who is on the Zoom.
All right, good afternoon, Ms. Stewart.
Hi, good afternoon.
And how are you related to this case?
Jamie Vantic is my biological sister, and I'm the adopted mother of Bella and Oliver now.
Okay. And what would you like the court to know?
My name is Carmen Stewart. I'm speaking today as the sister and the adopted mom of my sister's 2 young children.
This is one of the most powerful parts of any sentencing hearing, the ripple effect. Notice how the focus shifts from the crime itself to the lifelong consequences. Trauma isn't just a moment, it's a chain reaction. And here's something to think about. Should the justice system weigh this kind of ongoing suffering more heavily when deciding punishment?
Children do not have to live every day with the truth that their father violently murdered their mother, their grandparents, their uncle, and even the dog. No words can really describe the pain that act of violence brought into their lives. The day that she was taken, so much shattered everybody's world. She should still be here today, experiencing her amazing children and making memories with them. She was a very beautiful, kind, and strong mom who should be here raising them and living her fullest life. And the brutal way that her life ended and the lives of her loved ones were taken from everybody left a trauma that ripples through everybody. Every single day. The cruelty of her death is beyond comprehension, and the hole that's left is something that we'll never be able to fill. When I stepped in to adopt her children, it was without hesitation. They're a big part of her, and I love them fiercely, but I'd be lying if I said that it didn't change everything. We're all healing from trauma that most people can't even imagine. These children watched their whole world collapse. They struggle with nightmares, fear, confusion, and a deep sadness that no child should have to carry. I've had to explain things to them that nobody should ever have to explain to a child, and they ask questions that I should never have to answer. I see in their eyes every day the impact of what happened to them, and I carry their pain with me. Every day is a battle to restore a sense of safety for them, to assure them that they're loved and that the people they love aren't going anywhere, and to help them rebuild trust in a world that was so unsafe for them. That was made so unsafe for them by the person whose role it was to keep them safe and healthy. They live with a deep-seated distrust in the world and the people that they love.
And here it is, the moment that always sparks debate. The victim's family explicitly supports the death penalty. Not out of revenge, they say, but protection. This raises a difficult question. Should sentencing ever factor in what the family wants, especially in capital cases? Or should justice remain completely detached from emotion?
The scumbag that was responsible for causing them this pain was their father, because somebody was supposed to protect them from violence. Our lives were permanently altered. I rearranged everything, my home, my work, all my plans for the future to create a safe and loving environment for them. And I do it with all my heart because they really deserve that and more. But the cost of Shelby's actions goes far beyond just this moment of violence. It still ripples through every corner of our lives and continues to affect us every day. There's really no punishment that will undo this trauma, and there's nothing that can bring back the people that we lost. But please remember that his choices didn't just end lives. They stole peace, safety, and joy from so many people, especially the 2 innocent children here who must now grow up without their mother, their grandparents, and the family that should be their support system. As a victim in this case, I want to be clear, I do support the death penalty, not out of revenge, but out of necessity for the safety and peace of the children that he left behind. I cannot risk them ever having the opportunity to reach out to them as they grow up, to twist the truth, to manipulate their minds, or cause more trauma and confusion than they've already endured. They deserve a chance to heal without the looming shadow of their biological father trying to re-enter their lives or rewrite history. We are trying to rebuild, and we're surviving something nobody should ever have to survive. This punishment can't bring back our loved ones, but it can ensure that he doesn't cause us harm again. We are healing and growing, but we are forever changed. So thanks for allowing me to speak.
Thank you. All right, State, anyone else? Anything else, ma'am?
No, that's everything. Thank you.
All right. State, anyone else who would like to address the court at this point?
No, Judge.
All right, very good. Defense, anyone who would like to address the court?
No, Your Honor. Thank you. I just spoke with Mr. Neely, and he would prefer not.
All right. Any reason I should not proceed to the sentencing at this point? Anything else that either the state or the defense wants to say?
No, Judge.
No, Your Honor.
Defense, all right. All right, well, this may seem like it's very unimportant, mainly because it is, but I think we have to deal with fees and costs just because we have to under the law. Now, Chapter 775.083 states that a person who has been convicted of any offense other than a capital felony may be sentenced to pay a fine. So obviously, this is a capital felony, so there's no fines, but there are minimum mandatory costs in every case, so I think they still apply. So with an adjudication, obviously there's going to be an adjudication here because it's mandatory. We have minimum costs of $368. We also have $100 for costs of prosecution, $100 for the services of the defense counsel, which obviously seems extraordinarily reasonable under the circumstances. For counts 2 and 3, we have $50 for crime prevention, and the defendant did have the public defender's office originally, so we have $50 for the public defender application fee. Now, I believe that counts 4, 5, and 6 have already been dealt with as far as the sentencing is concerned, and I believe the defendant got time served on all the aggravated cruelty to animal charges. Is that correct, Madam Clerk?
It was 5 years, which was essentially time served.
Oh, okay,
and
so
then
it was,
just the $50.
okay, so an adjudication, 5 years in the Department of Corrections, right? All right, so everyone agrees with that, right? All right, so what we have left are 3 counts of first-degree murder, and the court will proceed with the sentencing at this point. The defense can please rise. I don't think you'll be standing all that long here.
And Judge, in regards to cost, can I add some things?
Sure, absolutely.
The next of kin are looking for $30,000 for expenses of funeral and things of that nature. If the court would grant that. There's $7,329 to Florida Crimes Compensation Fund for outpays that were made on behalf of the victims there. There was $1,103.85 to extradite the defendant here, due and owing to the Pinellas County Sheriff's Office. And the Tarpon Springs Police Department broke down the expenses that they spent investigating the crime and came up with $65,807.23.
This is the legal core of the decision, aggravating factors versus mitigating circumstances. Think of it like a scale. The prosecution piles on reasons for a harsher punishment, while the defense adds context meant to humanize the defendant. Even though there are 41 mitigating factors here, the judge says they don't outweigh the severity of the crime. That tells you just how extreme the aggravating side must be.
So, putting that on there.
All right. Sometimes the state will just waive all those, but if the defense has no objection, I'll impose them.
We consulted with our client, he has no objection.
All right. Is that correct, Mr. Neely?
Yes, sir.
All right, so I'll go ahead and impose those. I don't know if Madam Clerk got all those numbers.
Can I just confirm that real quick? That was
Sure.
$30,000 for the funeral expenses.
Now, who does that go to? It has to go to somebody.
And just like that, it's done. 3 death sentences, delivered in under a minute. No dramatic music, no courtroom outbursts, just a matter-of-fact conclusion to something incredibly heavy. But here's what happens next. Automatic appeal. In death penalty cases, this is far from over. So the real question is, does this feel like justice or just the beginning of a much longer legal battle?
Richard Ivanchik is the executor of the estate.
Okay, very good.
And that was $30,000. I had $73.29 for crimes comp,
Correct.
1103.85. That was the extradition,
Correct.
and 65,807.23 to Tarpon Springs for invest.
Correct.
All right. All right, the court finds that the state has established 3 statutory aggravating factors beyond a reasonable doubt for each victim. The court further finds that the defense has established the existence of 3 statutory and 38 non-statutory mitigating circumstances. In weighing the aggravating factors against the mitigating circumstances, the court has carefully and thoroughly assessed the significance of each factor and circumstance. The court has given great weight to each aggravating factor. The aggravating factors outweigh the mitigators in this case, which, while numerous, do not reach the magnitude of the aggravating factors. The court has also given great weight to the jury's recommendation. Therefore, the court concludes that the defendant, under the laws of the state of Florida, has forfeited his right to live. Accordingly, it is ordered and adjudged that the defendant, Shelby Neely, is sentenced to death for the murder of Richard Vantic. It is further ordered and adjudged that the defendant, Shelby Neely, is sentenced to death for the murder of Laura Vantic. It is further ordered and adjudged that the defendant, Shelby Neely, is sentenced to death for the murder of Nicholas Vantic. The defendant will be committed to the custody of the Florida Department of Corrections for these sentences to be carried out as provided by law. The defendant is notified that his judgment and sentences are subject to automatic review by the Florida Supreme Court. Done and ordered here in Clearwater, Pinellas County on the 10th day of April 2026. All right, I do have a copy for each party of the sentencing order. It's a 21-page order, and then for anyone else who would like a copy of the order, I have copies here. All right, you may be seated. All right, so should I appoint the public defender's office for purposes of appeal?
Please, Your Honor, I was going to ask if you needed an order. However, I have filed a motion for new trial. I believe that was filed either today or maybe yesterday afternoon. I know normally the state, I don't know about this state attorney's office, but in the past, the state has not given a response to a motion for a new trial. And sometimes the court wants a hearing, sometimes the court will just decide on the merits of the motion. I believe that the motion is pretty thorough as I've gone through the transcript, including the Spencer hearing transcript. And so if the court wishes to issue an order based on the written motion, I don't have any objections.
All right, well, obviously, I'll take a look at it, and then if I think we need a hearing, I'll set a hearing, otherwise I'll rule on it. But I will appoint the public defender's office for purposes of appeal. All right, anything else before we adjourn? All right. Thank you.